I dare you to fix me. I'm crossing the line again, falling.
Bar Q 2004. CDC maintained a savings account with C Bank. On orders of the Regional Trial Court, the sheriff garnished $50,000 of his account to satisfy the judgment in favor of his creditor, MO. CDC complained that the garnishment violated the law on the secrecy of bank deposits because the existence of his savings account was disclosed to the public. Is CDC's complaint meritorious or not? No, CDC's complaint is not meritorious. It was held in China Banking Corporation versus Ortega that peso deposits may be garnished and the depository bank can comply with the order of garnishment without violating the law on the secrecy of bank deposits. Execution is the goal of litigation as it is fruit. Garnishment is part of the execution process. Upon service of the notice of garnishment on the bank where the defendant deposited funds, such funds become part of the subject matter of litigation. 2005. A high-yielding corporation filed a complaint against 5 of its officers for violation of Section 31st of the Corporation Code. The corporation claimed that the said officers were guilty of advancing their personal interests to the prejudice of the corporation, and that they were grossly negligent in handling its affairs. Aside from documents and contracts, the corporation also submitted in evidence records of the officers' US dollar deposits in several banks overseas: Boston Bank, Bank of Switzerland, and Bank of New York. For their part, the officers filed a criminal complaint against the directors of high-yielding corporation for violation of Republic Act No. 6426, otherwise known as the Foreign Currency Deposit Act of the Philippines. The officers alleged that their bank deposits were illegally disclosed for want of a court order, and that such deposits were not even the subject of the case against them. Will the complaint filed against the directors of high-yielding corporation prosper? No, because the Foreign Currency Deposit Act, RA 6426, including its punitive provisions, refers to foreign currency deposits accounts constituted within the Philippines. It has no application at all to accounts even though they are banks opened and constituted abroad. Was there a violation of the secrecy of bank deposits law? No, because the punitive provisions of the secrecy of bank deposits law, or RA 1405, including the statutory exemptions provided therein, are not applicable to FCDU accounts, even when constituted locally. Andrew is engaged in the business of building low-cost housing units under contracts with real estate developers. He applied for a loan of $3 million from Ready Credit Bank, the bank, which required Andrew to provide collateral security for it. Andrew offered to assign to the bank his receivable amounting to $4 million from Home Builders Development Corporation, the obligor. The bank accepted the offer. Accordingly, Andrew obtained the loan and he executed a promissory note undertaking to pay the loan in full in one lump sum on September 1st, 2002, together with interest thereon at the rate of 20% per annum. At the same time, Andrew executed a deed of assignment in favor of the bank, assigning to the bank his receivables from the obligor. The deed of assignment read, I, Andrew Lee, hereby assign, transfer, and convey absolutely and unconditionally to Ready Credit Bank, hereinafter called the bank, all of my right, title, and interest, and to my accounts receivable from Home Builders Development Corporation, hereinafter called the obligor, arising from delivery of housing units with a total contract price of $4 million, the description and contract value of which are attached hereto as Annex A, hereinafter called the receivables. In the event that I shall be unable to pay my outstanding indebtedness owed to the bank, The bank shall have the right, without any further formality or act on its part, to collect the receivables from the obligor and to apply the proceeds thereof toward payment of my said indebtedness. Andrew failed to pay the loan on its due date on September 1st, 2002. When the bank attempted to collect from the obligor, the bank discovered that the latter had already closed operations and liquidated all its assets. The bank sued Andrew for collection, but Andrew moved to dismiss the complaint on the ground that the debt had already been paid by reason of his execution of the aforesaid deed of assignment, which, being absolute and unconditional, was in essence a dación en pago. The bank opposed the motion, contending that the deed of assignment was only a security for a loan. If you were the judge, how would you resolve the motion to dismiss filed by Andrew? Since the question is outside the scope of the bar examination, it is recommended that the candidate be given full credit of 5%, whatever may be his answer, and be given a bonus if he made an answer in the following manner. Okay. The motion to dismiss should be granted. The simple, absolute, and unconditional conveyance embodied in the deed of assignment would be operative, and the assignment would constitute essentially a mode of payment, or dación en pago. Classification of banks. There are 6 classes of banks identified in the General Banking Law of 2000. Name at least 4 of them and explain the distinguishing characteristics or function of each one. 1. Universal banks. These are those which used to be called expanded commercial banks, and the operations of which are now primarily governed by the General Banking Law of 2002. They can exercise the powers of an investment house and invest in non-allied enterprises. They have the highest capitalization requirement. 2. Commercial banks. These are ordinary or regular commercial banks, as distinguished from a universal bank. They have a lower capitalization requirement than universal banks and cannot exercise the powers of an investment house and invest in non-allied enterprises. Thrift banks. These banks, such as savings and mortgage banks, stock savings and loan associations, and private development banks, may exercise most of the powers and functions of a commercial bank, except that they cannot, among others, open current or check accounts without prior monetary board approval, and they cannot issue letters of credit. Their operations are governed primarily by the Thrift Banks Act of 1995, or RA 7906. Ruler banks. These are those which are organized primarily to extend loans and other credit facilities to farmers, fishermen, or farm families, as well as cooperatives, merchants, and private and public employees, and whose operations are primarily governed by the Rural Banks Act of 1992, RA 7353. Cooperative banks. These are those which are organized primarily to provide financial and credit services to cooperatives and whose operations are primarily governed by the Cooperative Code of the Philippines, RA 6938. Islamic banks. These are those which are organized primarily to provide financial and credit services in a manner or transaction consistent with the Islamic Sharia. At present, only the AI Amana Islamic Investment Bank of the Philippines has been organized as an Islamic bank. Distinguish between the role of a conservator and that of a receiver of a bank. The conservator is appointed for a period not exceeding 1 year to take charge of the assets, liabilities, and the management of a bank or quasi-bank in a state of continuing inability or unwillingness to maintain a condition of liquidity deemed adequate to protect the interests of depositors and creditors. On the other hand, the receiver is appointed to manage a bank or quasi-bank that is unable to pay its liabilities in the ordinary course of business or has insufficient realizable asset to meet its liabilities or cannot continue in business without probable losses to its depositors or creditors, or has willfully violated a final cease and desist order involving acts or transactions amounting to fraud or a dissipation of the assets of the institution. The main purpose of the receiver is to recommend the rehabilitation or liquidation of the bank. Diligence required. Placido, a bank depositor, left his checkbook and his desk at his house. Unknown to him, a visitor at the time, noticing the same, took a check therefrom, filled it up in the amount of 3,000 and succeeded in cashing the check on the same day. Placido's account was thereby debited in the same amount. Discovering the erroneous debit, Placido demanded that the bank credit him with the like amount. The bank refused on the ground that Placido was negligent in leaving his checkbook and his desk so that he could not put up the defense of forgery or want of authority under the negotiable instrument law. The facts disclosed that even to the naked eye, there were marked differences between Placido's signature and the one in the check forged by the visitor. As between Placido and the bank, who should bear the loss? The bank should bear the loss. A doorway bank must exercise the highest diligence in safeguarding the accounts of its client depositors. The bank is also charged with genuineness of the signature of its current account holders. But what can be more striking is that there were marked differences between Placido's signature and the one in the check forged by the visitor. Certainly, Placido was not negligent in leaving his checkbook in his own desk. PNB versus Kimpo, 158, SCRA 582. Insolvency. The Monetary Board of the BSP closed Urban Bank after it encountered crippling financial difficulties that resulted in a bank run. X, one of the members of the BOD of the bank, attended and stayed throughout the entire meeting of the board that was held well in advance of the bank run and before news had begun to trickle to the business community about the dire financial pit the bank had fallen into. Immediately after the meeting, X caused the preparation and issuance of a manager's check payable to himself in the sum of 5 million pesos, equivalent to the amount placed or invested in the bank by a business acquaintance. He now claims that he had committed no violation of the General Banking Act, RA 337, as amended, for which he should be punished. Do you agree that there had been no violation of the statute? No, I do not agree that there is no violation of the statute, RA 337, as amended. X violated Section 85 when he caused the preparation and issuance of a manager's check payable to himself in the sum of 5 million. This is paying out or permitting to be paid out funds of the bank after the latter became insolvent. This act is penalized by fine of not less than 1,000 nor more than 10,000 and by imprisonment for not less than 2 or more than 10 years. Give the basic requirements to be complied with by the BSP before the Monetary Board can declare a bank insolvent, order it closed, and forbid it from doing further business in the Philippines. Before the Monetary Board can declare a bank insolvent, order it closed, and forbid it from doing further business in the Philippines, the following basic requirements must be complied with by the BSP to it. 1. There must be an examination by the head of the Department of Supervision of, or his examiners or agents into the condition of the bank. The examination discloses that the condition of the bank is one of insolvency, or that its continuance in business would involve probable loss to creditors or depositors. 3. The head of said department shall inform in writing the Monetary Board of such facts. 4. Upon finding said information or statement to be true, the Monetary Board shall appoint a receiver to take charge of the assets and liabilities of the bank. 5. Within 60 days, The monetary board shall determine and confirm if the bank is insolvent and public interest requires to order the liquidation of the bank. Restriction on loan accommodations. As part of the safeguards against imprudent banking, the General Banking Law imposes limits or restrictions on loans and credit accommodations which may be extended by banks. Identify at least two of these limits or restrictions and explain the rationale of each of them. SBL rules, that is, single borrowers limit rules are those promulgated by the Bangko Sentral ng Pilipinas upon the authority of Section 35 of the General Banking Law of 2000, which regulate the total amount of loans, credit accommodations, and guarantees that may be extended by a bank to any person, partnership, association, corporation, or other entity. The rules seek to protect a bank from making excessive loans to a single borrower by prohibiting it from lending beyond a specified ceiling. DOSRI or DOSRI rules. These rules, promulgated by the BSP upon authority of Section 5 of the General Banking Law of 2000, which regulate the amount of credit accommodations that a bank may extend to its directors, officers, stockholders, and their related interests. Generally, a bank's credit accommodations to its DOSRI must be in the regular course of business and on terms not less favorable to the bank than those offered to non-DOSRI borrowers. 3. No commercial bank shall make any loan or discount on the security of shares of its own capital stock. Restriction on Loan Accommodations, 2006. Pio is the president of Western Bank. His wife applied for a loan with the said bank to finance an internet cafe. The loan officer told her that her application will not be approved because the grant of loans to related interests of bank directors, officers, and stockholders is prohibited by the General Banking Law. Explain whether the loan officer is correct. Section 36 of the General Banking Law of 2000 does not entirely prohibit directors or officers of the bank, directly or indirectly, from borrowing from the bank. In this case, Pio is the president of Western Bank, which makes him an officer, director, and stockholder of the said bank. The General Banking Law provides for additional restrictions to the bank before it can lend to its directors or officers. A written approval of the majority vote of all the directors of the bank, excluding the director concerned, is required. Furthermore, such dealings must be upon terms not less favorable to the bank than those offered to others. Section 132(6) Central Banks Manual of Regulations for Banks and Other Financial Intermediaries, cited in Ranioso v. CA. A violation of this provision will cause his or her position to be declared vacant and the erring director or officer subjected to the penal provisions of the new Central Bank Act. MN and OP rented a safety deposit box at Cbank. The parties signed a contract of lease with the conditions that the bank is not a depository of the contents of the safe and has neither the possession nor control of the same. The bank assumed no interest in said contents and assumes no liability in connection therewith. The safety deposit box had two keyholes, one for the guard key, which remained with the bank, and the other for the renter's key. The box can be opened only with the use of both keys. The renters deposited certificates of title in the box, but later they discovered that the certificates were gone. MN and OP now claim for damages from Cbank. Is the bank liable? The bank is liable based on the decisions of the Supreme Court in CA Agro-Industrial Development Corporation versus Court of Appeals and CIA versus Court of Appeals. In those cases, the Supreme Court ruled that the renting out of a safety deposit boxes is a special kind of deposit wherein the bank is the depository. In the absence of any stipulation prescribing the degree of diligence required, that of a good father of a family is to be observed by the depository. Any stipulation exempting the depository from any liability arising from the loss of the thing deposited would be void for being contrary to law and public policy. The deposit box is located in the bank premises and is under the absolute control of the bank. Rudy is jobless but is reputed to be a wedding operator. He has never been charged or convicted of any crime. He maintains several bank accounts and has purchased 5 houses and lots for his children from the Luansing Realty Incorporated. Since he does not have any visible job, the company reported his purchases to the Anti-Money Laundering Council, AMLC. Thereafter, AMLC charged him with violation of the anti-money laundering law. Upon request of the AMLC, the bank disclosed to it Rudy's bank deposits amounting to $100 million. Subsequently, he was charged in court for violation of the anti-money laundering law. Can Rudy now move to dismiss the case on the ground that he has no criminal record? No. Under the anti-money laundering law, Rudy would be guilty of a money laundering crime committed when the proceeds of an unlawful activity like wedding operations are made to appear as having originated from legitimate sources. The money laundering crime is separate from the unlawful activity of being a wedding operator and requires no previous conviction for the unlawful activity. To raise funds for his defense, Rudy sold the houses and lots to a friend. Can Luansing Realty be compelled to transfer to the buyer ownership of the houses and lots? Luansing Realty Inc. is a real estate company, hence it is not a covered institution under Section 3 of the Anti-Money Laundering Act. Only banking institutions, insurance companies, securities dealers and brokers, pre-need companies and other entities administering or otherwise dealing in currency, commodities, or financial derivatives are covered institutions. Hence, Luansing Realty Incorporated may not use the Anti-Money Laundering Act to refuse to transfer to the buyer ownership of the houses and lots. In disclosing Rudy's bank accounts to AMLC, did the bank violate any law? No, the bank did not violate any law. The bank, being specified as a covered institution under the anti-money laundering law, is obliged to report to the AMLC covered and suspicious transactions, being thereby violating any law. This is one of the exceptions to the Secrecy of Bank Deposit Act. Supposing the titles of the houses and lots are in possession of the Luansing Realty, is it under obligation to deliver titles to Rudy? Yes, it has an obligation to deliver titles to Rudy. As Luansing Realty Inc. is not a covered institution under Section 3 of the Anti-Money Laundering Act, it may not invoke this law to refuse delivery to the titles to Rudy. Under Republic Act No. 1405, the Bank Secrecy Law, bank deposits are considered absolutely confidential and may not be examined, inquired, or looked into by any person, government official, bureau, or office. What are the exceptions? The exceptions to the Bank Secrecy Law are the following. 1. Special or general examination of a bank authorized by the Bangko Sentral ng Pilipinas Monetary Board in connection with a bank fraud or serious irregularity. 2. Examination by an independent auditor hired by the bank and for the bank's exclusive use. 3. Disclosure with the depositor's written permission in case of impeachment, in cases of bribery or dereliction of duty by a public officer upon order of a competent court, in cases of money deposited or invested, which in turn is the subject of litigation upon order of a competent court. 4. VOSRI loans, loans with their banks or bank directors, officers, stockholders, and related interests, loans in excess of 5% of the bank's capital and surplus, The borrower waived his right to record the secrecy of bank deposit. Number 5. Violation of the Anti-Graft and Corrupt Practices Act. Number 6. Coup d'etat Law Act. RA 6968, October 24, 1990. BIR Commissioner's authority to verify a dissident's gross estate. The taxpayer request for a compromise agreement due to incapacity to pay his tax liability. 8. Foreign currency deposits by foreign lenders and investors under Pdic 1034. 9. Violations of the anti-money laundering when the state exercises or invokes its policy or police power. Manosa, a newspaper columnist, while making a deposit in a bank, overheard a pretty bank teller informing a co-employee that Gigi, a well-known public official, had just a few hundred pesos in her bank account and that her next check will, in all probability, bounce. Manosa wrote this information in his newspaper column. Thus, Gigi filed a complaint with the City Fiscal of Manila for unlawful disclosing information about her bank account. Will the said suit prosper? Explain your answer. Supposing that Gigi is charged with unlawfully acquiring wealth under RA 1379 and that the fiscal issued a subpoena duces tecum for the records of the bank account of Gigi, may Gigi validly oppose the said issuance on the ground that the same violates the law on secrecy of bank deposits? Answer to letter A. The Secrecy of Bank Deposit Act prohibits, subject to its exclusionary clauses, any person from examining, inquiring, or looking into all deposits of whatever nature with banks or banking institutions in the Philippines, which by law are declared absolutely confidential in nature. Manosa, who merely overheard what appeared to be a vague remark of a bank employee to a co-employee, and writing the same in his newspaper column, is neither the inquiry nor disclosure contemplated by law. Alternative answer. The complaint against Manosa will not prosper because merely writing a vague remark of a bank employee to a co-employee is not the disclosure contemplated by law. If anyone should be liable, it will be the bank employee who disclosed the information. Letter B. Among the instances exempted from the coverage of the secrecy of bank deposits are anti-graft cases. Hence, Gigi may not validly oppose the issuance of a subpoena duces tecum for the bank records on her. The law RA 6832 creating a commission to conduct a thorough fact-finding investigation of the failed coup d'etat of December 1989 recommend measures to prevent the occurrences of similar attempts at a violent seizure of power and for other purposes, provides that the Commission may ask the Monetary Board to disclose information on and or to grant authority to examine any bank deposits, trust or investment funds, or banking transactions in the name of and or utilized by a person, natural or juridical, under investigation by the Commission in any bank or banking institution in the Philippines when the Commission has reasonable ground to believe that said deposits, trust or investment funds, or banking transactions have been used in support or in furtherance of the objectives of the said coup d'etat. Does the above provision not violate the law on secrecy of bank deposits? The law on secrecy of bank deposit is itself merely a statutory enactment, and it may therefore be modified or amended such as by providing further exemptions therefrom, or even repealed expressly or impliedly by subsequent law. The Secrecy Bank Deposits Act did not amount to a contract between the depositors and depository banks within the meaning of the Non-Impairing or Non-Impairment clause of the Constitution. Even if it did, the police power of the state is superior to Non-Impairment Clause, RA 6832, creating a commission to conduct an investigation of the failed 1989 coup d'etat and to recommend measures to prevent similar attempts to seize power is a valid exercise of police power. Socorro received $10,000 from a foreign bank, although she was entitled only to $1,000. In an apparent plan to conceal the erroneously sent amount, she opened a dollar account with her local bank, deposited the $10,000, and issued 4 checks in the amount of $2,000 and 1 check for $1,000, each payable to different individuals who deposited the same in their respective dollar accounts with different local banks. The sender bank then brought a civil suit before the RTC for the recovery of the erroneously sent amount. In the course of the trial, the sender presented testimonies of bank officials to show that the funds were, in fact, deposited in a bank of Socorro and paid out to several persons who participated in the concealment and dissipation of the amount that Socorro had erroneously received. Socorro moved to strike out said testimonies from the record, invoking the law on secrecy of bank deposits. If you were the judge, would you issue an order to strike them out? Why? I will not strike out the testimonies from the record. The testimonies of bank officials indicating where the questioned dollar accounts were opened in depositing misappropriated sums must be considered as likewise involved in litigation, one which is among the accepted cases under the Secrecy Bank Deposit. Melon Bank versus Magsino 19190 SCRA 633. Miguel, a special custom agent, is charged before the Ombudsman with having acquired property out of proportion to his salary in violation of the Anti-Graft and Corrupt Practices Act. The Ombudsman issued a subpoena de justicum to the Banco de Cinco, commanding its representative to furnish the Ombudsman records of transactions by or in the name of Miguel, his wife, and children. A second subpoena was issued expanding the first by including the production of records of friends of Miguel in said bank and in all its branches and extension offices, specifically naming them. Miguel moved to quash the subpoenas, arguing that they violate the secrecy of bank deposits law. In addition, he contends that the subpoenas are in the nature of fishing expedition or general warrants and are constitutionally impermissible with respect to private individuals who are not under investigation. Is Miguel's contention tenable? The answer is no. Miguel's contention is not tenable. The inquiry into illegally acquired property extends to cases where such property is concealed by being held by or recorded in the name of other persons. To sustain Miguel's theory and restrict the inquiry only to property held by or in the name of the government official would make available to persons in government who illegally acquire property an easy means of evading prosecution. All they have to do would be to simply place the property in the name of persons other than their spouses and children. Banco Filipino Savings versus Purisima. Michael withdrew without authority funds of the partnership in the amount of $550 for services he claims he rendered for the benefit of the partnership. He deposited the 500 pesos in his personal peso current account with Prosperity Bank and the US dollars in his personal foreign currency savings account with Eastern Bank. The partnership instituted an action in court against Michael, Prosperity, and Easter to compel Michael to return the subject funds to the partnership and pending litigation to order both banks to disallow any withdrawal from his accounts. At the initial hearing of the case, the court ordered Prosperity to produce the records of Michael's peso current account and Eastern to produce the record of his foreign currency savings account. Can the court compel Prosperity and Eastern to disclose the bank deposits of Michael? Yes. As far as the peso account is concerned, Section 2 of RA 1405 allows the disclosure of bank deposits in case where the money deposited is the subject matter of litigation. Since the case filed against Michael is aimed at recovering the amount he withdrew from the funds of the partnership, which amount he allegedly deposited in his account, a disclosure of his bank deposits would be proper. No, with respect to the foreign currency account, because under the foreign currency law, the exemption to the prohibition against disclosure of information concerning bank deposits is the written consent of the depositor. An insurance company is deluded into releasing a check to A for $35 to pay for treasury bills or T-bills, that's $35,000, which A claims to be an en route on board an armored truck from a government bank. The check is delivered to A, who deposited to his account with XYZ Bank before the insurance company realizes it is a scam. Upon such realization, the insurance company files an action against A for recovery of the amount defrauded and obtains a writ of preliminary attachment. In addition to the writ, the bank is also served a subpoena to examine the account records of A. The bank declines to provide any information in response to the writ and moves to quash the subpoena, invoking secrecy of bank. Under RA 1405 as amended, can the bank justifiably invoke RA 1405 and not respond to the writ and be quash the subpoena for examination? The answer is yes. Whether the transaction is considered a sale or money placement does not make the money subject matter of litigation within the meaning of Section 2 of RA 1405, which prohibits the disclosure or inquiry into bank deposit, except in cases where the money deposited or invested is the subject matter of litigation, nor will it matter whether the money was swindled. GP is a suspected wetting lord who is rumored to be enjoying police and military protection, the envy of many drug lords who had not escaped the dragnet of the law. GP was summoned to a hearing of the Committee on Racketeering and Other Syndicated Crimes of the House of Representatives, which was conducting a congressional investigation in aid of legislation on the involvement of police and military personnel, and possibly even of local government officials, in the illegal activities of suspected gambling and drug lords. Subpoenaed to attend the investigation were officers to certain identified banks with its directive to them to bring the records and documents of bank deposits of individuals mentioned in the subpoenas, among them GP. GP and the bank opposed the production of the bank's record of deposits on the ground that no such inquiry is allowed under the law on secrecy of bank deposits. Is the opposition of GP and the banks valid? Yes, the opposition is valid. GP is not a public official. The investigation does not involve one of the exceptions to the prohibition against disclosure of any information concerning bank deposits under the law on secrecy of bank deposits. The committee conducting the investigation is not a competent court or the ombudsman authorized under the law to issue a subpoena for the production of the bank record involving such disclosure. The law on secrecy of bank deposits provide that all deposits of whatever nature with banks or banking institutions are absolutely confidential in nature and may not be examined, inquired, or looked into by any person, government official, bureau, or office. However, the law provides exceptions in certain instances. Which of the following may not be among the exceptions? In case of impeachment, in cases involving bribery, in cases involving bare inquiry, anti-graft and corrupt practices, in cases where the money involved is the subject matter of litigation. Which among these is the exception? Under Section 6F of the National Internal Revenue Code, the Commissioner of Internal Revenue can inquire into the deposits of a decedent for the purpose of determining the gross estate of such decedent. Apart from this case, a BIR inquiry into bank deposits cannot be made. Thus, Exception 3 may not always be applicable. Turning to Exception 4, an inquiry into bank deposit is possible only in prosecutions for unexplained wealth under the Anti-Graft and Corrupt Practices Act, according to the Supreme Court, in the cases of Philippine National Bank versus Gancaico. However, all other cases of anti-graft and corrupt practices will not warrant an inquiry into bank deposits. Thus, Exception 4 may not always be applicable. Like any other exception, it must be interpreted strictly. Exceptions 1, 2, and 5, on the other hand, are provided expressly in the law on secrecy of bank depositors. They are available to depositors at all times. The law on secrecy of bank deposits, otherwise known as R8 1405, is intended to encourage people to deposit their money in banking institutions and also to discourage private hoarding so that the same may be properly utilized by banks to assist in the economic development of the country. Is a notice of garnishment served on a bank at the instance of a creditor of a depositor covered by the said law? State the reason. No, the notice of garnishment served on a bank at the instance of a creditor is not covered by the law on secrecy of bank deposits. Garnishment is just a part of the process of execution. The moment a notice of garnishment is served on a bank and there exists a deposit by the judgment debtor, the bank is directly accountable to the sheriff for the benefit of the judgment creditor for the whole amount of the deposit. In such event, the amount of the deposit becomes in effect a subject of the litigation. Family Bank was placed under statutory receivership and subsequently ordered liquidated by the central bank due to fraud and irregularities in its lending operations, which rendered it insolvent. Judicial proceedings for liquidation were thereafter commenced by the central bank before the RTC. Family Bank opposed the petition. Shortly thereafter, Family Bank filed in the same court a special civil action against the central bank, seeking to enjoin and dismiss the liquidation proceedings on the ground of grave abuse of discretion by the central bank. The court poised to 1. Restrain the central bank from closing Family Bank, and 2. Authorize Family Bank to withdraw money from its deposits during the pendency of the case. If you were the judge, would you issue such orders? Why? No, the RTC has no authority to restrain the Monetary Board of the BSP from statutory authority to undertake receivership and ultimate liquidation of a bank. Any opposition to such an action could be made to the court itself, where assistance is sought. The action of the RTC where the proceeding is pending appeal have to be made in the Court of Appeals. After many years of shopping in Metro Manila area, housewife H.W. has developed a sound habit of making cash purchases only, none on credit. In one shopping trip to Mega Mall, she got the shock of her shopping life for the first time. A store-smart sales girl refused to accept her coins in payment for a purchase worth not more than 100 pesos. H.W. was paying 70 pesos in 25 centavo coins and 25 pesos in 10 centavo coins. Strange as it may seem, the sales girl told H.W. that her coins were not legal tender. Do you agree with the sales girl in respect of her understanding of legal tender? No, the sales girl understanding that coins are not legal tender is not correct. Coins are legal tender in amounts not exceeding 50 pesos for denominations from 25 centavos and above, and in amounts not exceeding 20 pesos for denominations 10 centavos and less. An employee of a large manufacturing firm earns a salary which is just a bit more than what he needs for a comfortable living. He is thus able to still maintain a 10,000 savings account, a 20,000 checking account, a 30,000 money market placement, and a 40,000 trust fund in medium-sized commercial bank. State which of the four accounts are deemed insured by the Pdic. State which of the above accounts are covered by the law on secrecy of bank deposits. Letter A. The 10,000 savings account and the 20,000 checking accounts are deemed insured by the Pdic. The 10,000 savings account and the 20,000 checking are covered by the law on secrecy bank of deposit. Responsibilities and objectives. What are the responsibilities and primary objectives of the BSP? The BSP shall provide policy directions in the areas of money, banking, and credit. It shall have supervision over the operations of banks and exercise such regulatory powers as provided in the Central Bank Act and other pertinent laws over the operation of finance companies and non-bank financial institutions performing quasi-banking functions such as quasi-banks and institutions performing similar functions. The primary objective of the BSP is to maintain price stability conducive to a balanced and sustainable growth of the economy. It shall promote and maintain monetary stability and convertibility of the peso. Giannina purchased on a 36-month installment basis the latest model of the Nissan Sentra sedan car from the Jubel Cars. In addition to the advertised selling price, the latter imposed finance charges consisting of interests, fees, and service charges. It did not, however, submit to Dana a written statement setting forth therein the information required by the Truth in Lending Act. Nevertheless, the conditional deed of sale, which the parties executed, mentioned that the total amount indicated therein included such finance charges. Has there been substantial compliance of the aforesaid Act? If your answer to the foregoing question is in the negative, what is the effect of the violation on the contract? In the violation of the Act, what remedies may be availed of by Dana? There was no substantial compliance with the Truth in Lending Act. The law provides that the creditor must make a full disclosure of the credit lost. The statement that the total amount due includes the principal and the financial charges without specifying the amounts due on each portion thereof would be insufficient and unacceptable. B. A violation of the Truth in Lending Act will not adversely affect the validity of the contract itself. C. It would allow Dana to refuse payment of financial charges or, if already paid, to recover the same. Dana may also initiate criminal charges against the creditor. Embassy Appliances sells home theater components that are designed and customized as entertainment centers for consumers within the medium to high price bracket. Most, if not all, of these packages are sold on installment basis, usually by means of credit cards allowing a maximum of 36 equal monthly payments. Preferred credit cards of this type are those issued by banks, which regularly hold mall-wide sales blitzes participated in by appliance retailers like Embassy Appliances. You are a buyer of a home theater center at Embassy Appliances. The sales clerk who is attending to you simply swipes your credit card on the electronic approval machine, which momentarily prints out your charge slip since you have unlimited credit, tears the slip from the machine, hands the same over to you for your signature, and boom, without more, proceeds to arrange the delivery and installation of your new home theater system. You know you will receive a statement on your credit card purchases from the bank containing an option to pay only a minimum amount, which is usually 1/36 of the total price you were charged for your purchase. Did embassy appliances comply with the provision of the Truth in Lending Act? There is no need for embassy appliance to comply with the Truth in Lending Act. The transaction is not a sale on installment basis. Embassy appliances is a seller on cash basis. It is the credit card company which allows the buyer to enjoy the privilege of paying the price on installment basis. Stunrose Inc., a department store with outlets in Makati, Mandaluyong, and Quezon City, is contemplating to refurbish and renovate its Makati store in order to introduce the most modern and state-of-the-art equipment in merchandise display. To carry out its plan, it intends to sell all of the existing fixtures and equipment, display cases, wall decorations, furniture, counters, etc., to Crossroads department store. Thereafter, it will buy and install new fixtures and equipment and continue operations. Crossroads want to know from you as counsel: number 1, whether the intended sale is bulk sale. Number 2, how can it protect itself from future claims of creditors of Stanras? 1. Yes, the sale involves all fixtures and equipment not in the ordinary course of trade and the regular prosecution of business of Stanros Incorporated. Number 2, Crossroads should require from Stanros Incorporated submission of a written waiver of the bulk sales law by the creditors as shown by verified statements, or to comply with the requirements of the bulk sales law. That is, the seller must notify his creditors of the terms and conditions of the sale, and also, before receiving from the vendee any part of the purchase price, deliver to such vendee a written sworn statement of the names and addresses of all its creditors, together with the amount of indebtedness due to each. Company X, engaged in the business of manufacturing car parts and accessories, operates a factory with equipment, machinery, and tools for this purpose. The manufactured goods are sold wholesale to distributors and dealers throughout the Philippines. Company X was among the business entities adversely hit by the 1997 Asian business crisis. Its sales dropped with a decline in car sales and its operating costs escalated, while its creditor bank and other financial institutions tightened their loan portfolios. Company X was faced with the dismal choice of either suspending its operations or selling its business. It chose the latter, having struck a deal with Company Z, a more vile company engaged in the same business. Company X sold its entire business to the former without much fanfare or any form of publicity. In fact, evidence exists that the transaction was furtively entered into to avoid the prying eyes of Company X creditors. The creditor banks and other financial institutions sued Company X for violation of the bulk sales law. Company X violated the bulk sales law when it sold its entire business to Company C furtively to avoid the prying eyes of its creditors. Its manufactured goods are sold wholesale to distributors and dealers. The sale of all or substantially all of its stocks, not in the ordinary course of business, constitutes bulk sale. The transaction being a bulk sale, entering into such transaction without complying with the requirements of the bulk sales law, Company X violated said law. Pursuant to a writ of execution issued by the Regional Trial Court in Express Bank versus Don Rubio, the sheriff levied and sold at public auction 8 photocopying machines of Don Rubio. Is the sheriff sale covered by the bulk sales law? No. The sale by sheriff at public sale is not a sale by a merchant. Section 8 of the bulk sales law itself provides that it has no application to executors, administrators, receivers, assignees in insolvency, or public officers acting under process. The bulk sales law only applies to the sale of or encumbrance of a merchant of goods, merchandise, or commodity done in bulk, as defined by the law itself. In the annual meeting of XYZ Corporation, the stockholders unanimously adopted a resolution proposed by the BOD to sell substantially all the fixtures and equipment used in and about its business. The president of the corporation approached you and asked for legal assistance to effect the sale. 1. What steps should you take so that the sale may be valid? Number 2. What are the two instances when the sale, transfer, mortgage, or assignment of stock of goods, wares, merchandise, provision, or material otherwise than in the ordinary course of trade and the regular prosecution of the business of the vendor are not deemed to be a sale or transfer in bulk? Number 1. The requirement of the bulk sales law must be complied with. The seller delivers to the purchaser a list of his creditors, and the purchaser in turn notifies such creditors of the proposed sale at a stipulated time in advance. Number 2. If the sale and transfer is made by the vendor, mortgager, transfer, or assigner who produces and delivers a written waiver of the provision of the bulk sales law from his creditors as shown by verified statement and by a vendor, mortgager, transfer, or assigner who is an executor, administrator, receiver, assignee in insolvency, or public officer acting under judicial process, the sale or transfer is not covered by the bulk sales law. House of Pizza is the owner and operator of a nationwide chain of pizza outlets. House of Liquor is a retailer of all kinds of liquor. House of Foods has offered to purchase all of the outlets, equipment, fixtures, and furniture of pizza. Foods also offered to purchase from Liquor all of its moderately priced stock constituting 50% of its total inventory. Both Pizza and Liquor have creditors. What legal requirements must Pizza and Liquor comply with in order for Foods to consummate the transaction? Pizza and Liquor must prepare an affidavit stating the names of all their creditors, their addresses, the amounts of their credits, and their respective maturities. Pizza and Liquor must submit said affidavit to Foods, which in turn should notify the creditors about the transaction which is about to be concluded with Pizza and Liquor. Alternative answer: as far as Liquor is concerned, it must prepare an affidavit stating the names of all its creditors, their addresses, the amounts of their credits, and their respective maturities. It must submit said affidavit to its buyer, who in turn should notify the creditors about the transaction which is about to be concluded with his seller. But as far as Pizza is concerned, it is not covered by the bulk sales law, so Foods can consummate the transaction without doing anything. Suppose A submitted a false statement on the schedule of his creditors. What is the effect of such a false statement as to vendee B? If the vendee does not have knowledge of the falsity of the schedule, the sale is valid. However, if the vendee has knowledge of such falsity, the sale is void because he is in bad faith. One question in consumer protection law. Metric system law. Angeline is a consumer of Meralco Electric Company, or MECO. Because of the abrupt rise in electricity rates, Angeline complained with MECO, insisting that she should be charged the former rates. However, Angeline did not tender any payment. When MECO's employees served the first 48-hour notice of disconnection, instead its employees examined Angeline's electric meter, changed the same, and installed another. Still, Angeline made no tender of payment. MECO served a second 48-hour notice of disconnection on June 22nd. It gave Angeline until 5 p.m. of June 25, within which to pay. As no payment had been made, Mako cut Angeline's electric service on June 28. Angeline contends that the 48-hour written notice of disconnection rule cannot be invoked by Mako. When there is a bona fide and just dispute as to the amount due as her electric consumption rate, is Angeline's contention valid? No. Angeline's only legal recourse in this case was to pay the electric bill under protest. Her failure to do so justified Mako to cut the electric service.